Welcome to You Counsel. On a daily basis in our courts, judges have to decide whether to believe a particular witness or not. How do they make that decision? What magical tools do they have at their disposal? What kind of principles they keep in mind in deciding the credibility of a witness is the topic of today's lecture. We begin with our disclaimer that this lecture is not legal advice, so if you have any specific questions regarding your issues, you should contact a lawyer or a paralegal or the Law Society of Ontario for a referral. Now, this witness credibility issue is most pronounced in he said, she said cases. In cases where there are two witnesses which have conflicting oral evidence about an incident, and the judges have to decide which witness is telling the truth and which witness is not to be believed. So in cases where there is minimal or no documentary evidence, this issue is common. Where there's conflicting documentary evidence or conflicting viva voce or oral evidence, as I said, between two witnesses, both have witnessed the same incident but have different evidence with respect to what occurred in that incident. And then there may be minimal or conflicting extraneous evidence. There may not be any third-party other witnesses or may not be any other documentary evidence that shed lights on the issue that is being decided by the judge. So how do the judges make that decision? We have a common misconception for a lot of people who come to the court and who have no legal experience, that the judges make decisions about credibility of a witness based on how sincere that witness appears to be. So this appearance of sincerity is sort of a broad term that is used, and it has many manifestations. So, for example, in a case where there are emotional elements, where there's issues, for example, of sexual assault or things of that nature, if the witness is crying when describing that particular instance, does that make the witness more believable? Is a witness sounds more educated when he or she is rendering testimony? Is the witness using a language that resonates more with the judge? How is the witness dressed? Is the witness dressed in professional clothes? What kind of color of their tie that they're wearing? I mean, these are things that we notice commonly in our everyday life, and especially we notice these kind of things in political debates that happen during the election time, right? So there's a lot of thought that goes into how a candidate is going to perform in an election debate. What kind of clothes they're wearing, what kind of suit they're wearing, what is the color of their suit, what is the color of their tie, whether they need to have, what kind of haircut they need to have, and how do they come across. So, for example, in Hillary Clinton's campaign, one of the common criticism was that she came across as very cold, right? So what has a coldness of a person to do anything with that person's credibility, right? But we trust people who are more warm. We connect with people who come across as a bit more warm, right? So these are the things on a daily basis, how a lot of us make decisions about credibility of a person who is before us. So when we come to court, we're worried. A lot of witnesses are worried that a witness who is a better performer in court than them will be accepted as more credible. And that is sort of a common misconception. And that is obviously a concern for people who believe that they do not come across as very well educated, very eloquent witnesses. But that is not how the courts decide on the credibility of witnesses, or at least that is how they try not to decide on the credibility of witnesses. I do believe that judges have their unconscious biases that play into decision making and with respect to the credibility of witnesses too. But the courts have made significant efforts in laying out principles of determining credibility assessments, and they follow those principles, or at least try to follow those principles. So one of the factors that court will consider is what kind of opportunities for knowledge of that incident that this witness is describing had with respect to that incident, right? So was the person present in that incident? How far was that person? How far, what was the concentration level? Was the person involved in that incident, or was it a bystander? What was the bystander doing? So what were the opportunities for knowledge of that incident that the witness is describing. What were the powers of observation? Again, this is relating to the opportunities of knowledge. But if you were watching television and something happened outside of your window, what was your ability to go? Was it the dark in the night? Was the outside? Was it day or night? Or were you able to see clearly? Were there street lights or not? Things like that. So power of observation of the witness. And then witnesses make judgment about a lot of facts that they see. So what kind of judgments that the witness has made? What was the memory? What is the extent of memory of that witness on that incident? And then relating to that is a witness's ability to describe clearly what was seen or heard. It has a value with respect to credibility. And then one of the major things that you want to focus on with respect to a witness's evidence is inconsistencies in the witness's evidence and weaknesses in the witness's evidence, right? And that is one thing that we as lawyers focus tremendously on, especially if we are trying to prove that a witness is not credible. So what are some of the internal inconsistencies? So for example, if the witness was describing an incident and earlier on in his or her testimony, the witness said that there were 3 other people who also were present in that situation, and then later on at some other point the witness says that there were 5 other witnesses who were present, then this shows an internal inconsistency in the recollection of the witnesses, and so you can expose that depending upon the circumstances of the case. Another inconsistency that can be shown is inconsistency with prior statements. So with respect to, for example, an accident, the witness did provide a statement to the police at the time of the accident, and now when the witness is testifying at trial, the testimony that he or she is providing is inconsistent with what was said to the police at the time of the accident. So showing that there were prior inconsistent statements, you can show that the witness is not credible, right? And then inconsistency with other witnesses, you juxtapose the witness's evidence with respect to other evidence and figure out what kind of inconsistencies there may be, or inconsistencies with some of the documents that are in evidence, and how do you assess the witness's credibility with respect to those inconsistencies. So inconsistencies is sort of the hallmark of a good lawyer who exposes inconsistencies and weaknesses in a witness's evidence to prove to the court or to show to the court that the witness is not credible. And this is done in a number of ways, but one of the common things that lawyers do all the time at the examinations for discovery at a trial is to approach one specific fact with different angles at different times of their examination. So they're bringing the same facts again and again in different ways to see if the witness provides some testimony that is inconsistent with whatever the witness has said before, right? So there are so many ways to do that, but inconsistencies is sort of one of the key things that lawyers at least try to find in a witness's evidence. And the judges are cautious that if there are inconsistencies and weaknesses in witness's evidence, then it will be hard for a judge to find that witness was credible. Having said that, another major thing that the court consider is whether the overall evidence of that witness is plausible. And this is the language used in a very famous case, which is sort of the seminal case on credibility of witnesses, Farina versus Chorney. And the court said, in harmony, is the witness's testimony in harmony with the preponderance of probabilities which a practical and informed person would readily recognize as reasonable in that place and in those conditions. So what it means is, does the witness's evidence make sense when you consider the entire of the story? Does it make sense? And if it doesn't make sense, then it's hard for the judge to believe that witness. And if it does, then it's more plausible. And in all of this, the demeanor of the witness, the sincerity and the use of the language is considered, but with caution, right? So it is not something that the judge will take right away, that the person comes across as sincere and honest, and therefore to believe that person. No, it is considered, but with some caution. And then also the motives of that witness with respect to fabricating evidence are also considered. Now, when a judge has to decide to believe a witness or not, how much does a judge need to believe a witness? So it's not all or nothing kind of situation. The court may believe none of the witness's evidence, part of his or her evidence, or all of the witness's evidence. So it is possible for the court to say, I believe this part of the witness's testimony, but I do not believe that part of the witness's testimony. So it's not an all or nothing proposition. And then when the court accepts the evidence, it may assign different weight to different parts of the evidence, right? So when the court says, I believe that this person is telling the truth, the evidence is credible, that does not mean that the court has to then make a finding of fact on the basis of that witness's evidence alone. Right, so court may say, we're going to consider this as something that supports this fact, but we're going to look at some other facts too, right? So they may assign a different weight to that testimony or different parts of the testimony. So one part of the evidence, they may say, we believe it 100%. We're going to rule that this is how the fact was as described by this witness, or they may say that we're going to believe it. We're going to assign a lower weight, a less weight to this part of the evidence. So that is open to the court with respect to the evidence. So what is the takeaway? You need to always remember that unreliable witnesses can seriously undermine the success of a case. So it's very important that the witnesses that are presented are credible and they provide evidence that is credible. Two cases I would recommend that you read: Farina versus Chorney. This is sort of the leading case with respect to assessment of credibility of a witness. And it is a treat to read this case. I think you can read it over and over again to understand this is relied on by courts all the time. And so read that case. And then another one which is helpful is Frame versus Rye, which actually expands upon some of the principles that are stated in Farina versus Chorney, and it will be helpful. Thank you for watching.